Margins, a collaborative initiative between Sugandha Bhandare Foundation and QAble. We are especially glad to see so many members of the bar and the bench here. I would formally like to invite Justice Manmohan, Justice Lokar, and Justice A.K. Sikri to initiate the lighting of the lamp. Yes, of course, Anchal. Thank you for marking the beginning of today's important dialogue. Your presence speaks volume to the shared belief that justice must be inclusive, accessible, and grounded in lived realities. I now invite Ms. Shreya Singhal to deliver the welcome address. I would now like to request the panelists from the first panel, moderated by Amar, to kindly join us on the stage.
Good morning, everyone. May I first request everyone to please put your phones and tablets on silent. Uh, and as an extra thank you for coming here on a Saturday morning so early, especially our panelists who have come for the next sessions a little earlier to enjoy this session. So thank you very much. Justice Manmohan, Justice Sikri, Mr. Rahul Bajaj, Mr. Praveen Prakash Ambasta, I welcome you all to the seminar Judging and Lawyering at the Margins. The issue of accessibility to the courts was very close to my grandfather's heart. During his career, he took up and made this issue his own. Under his vision for equality, the Justice Sunanda Bhandari Foundation filed a public interest litigation before the Honorable Supreme Court of India for the implementation of the Persons with Disabilities Act 2016. The Honorable Supreme Court of India was pleased to pass directions for its implementation by all state and union territories in letter and spirit and continues to monitor this till today. Cuable is a community led initiative founded by Achal S. Bhatija, focused on foregrounding the intersections of queerness and disability in law and public policy. Cuable works through capacity building, sensitization, training, awareness campaigns, strategic advocacy, and community outreach. It aims to make legal, education, and institutional spaces more inclusive, accessible, and affirming for disabled and queer individuals. In today's day and age where accessibility has come into the foreground and not on the fringes and in the background, both the Justice Bhandari Foundation, Sunanda Bhandari Foundation, and Cuable today welcome all of you in this discourse so that we can move forward and not leave this in the fringes and bring it to its rightful conclusion to give inclusivity to everyone every day. Last but not least, I welcome you all, students, teachers, lawyers, media persons, and volunteers whose unstinted support has encouraged and motivated us to carry forward the work that both the Justice Sunanda Bhandari Foundation and Cuable have started. Thank you so much.
Should I take over? Okay, sure. Good morning, everyone, and thank you for joining us on this Saturday morning. We are going to talk to STEAM panelists, and I'm going to introduce one by one. To my left, I'm joined by Honorable Justice Sikri, former judge of Supreme Court, and I'm proud to say he is a patron and chief of Mission Accessibility. He time and again guides us, mentors us on strategy when it comes to disability rights litigation. Then I'm joined by Justice Manmohan, sitting judge of Supreme Court. I've had the pleasure of appearing before Justice Manmohan when he was acting Chief Justice of Delhi High Court. He's been very pointed in his questions, I must say, and someone who passionately drove the cause of persons with disabilities when I had the pleasure of appearing before him in Delhi High Court, be it access to currency and financial inclusion, and be it even animal menace matter, where Justice Manmohan remarked when Rahul was arguing that this blind man has a right to walk on the street. And it was very affirmative to see this coming from a judge like him back then. So pleased to have you here, sir. Next to Justice Manmohan, I have Praveen Prakash Ambasta, sir. He is a Deputy Chief Commissioner for Persons with Disabilities at the Court of Chief Commissioner for Persons with Disabilities. Someone who has really driven the cause of disability with passion, understanding of law, and lived, connecting with users who have lived experiences of being persons with disabilities. So thank you for joining us, sir, today. And next to him is my co-founder, my partner in crime, Rahul Bajaj, co-founder at Mission Accessibility and also partner at Zen Access Law Associates, a law firm that is led by persons with disabilities but not limited by disability. Rahul is someone, I know him since 2010, I think, and he's someone who has really, in a very short span of time, ever since he began formally his career in disability rights litigation, apart from being a mainstream professional, has earned a huge respect in minds of clients, in minds of people, legal fraternity, and in minds of judges alike. Everybody wants today Rahul Bajaj on a specific matter whenever there is a complex question of law involved. So pleased to have everybody here. Uh, so when we think of judging and lawyering from a disabilities perspective, and especially from clients with disabilities perspective, there are a lot of things that come to my mind. I'll just set some context. Just to introduce myself, I'm I'm Amar Jain. I'm a corporate lawyer and an accessibility professional. I have worked with Trilegal and Sir Namalchand Mangaldas in banking and finance and capital markets. And now I lead, along with Rahul, Mission Accessibility as well as an Access Law Associates. That's a very basic about me. Uh, when it comes to talking about lawyering for persons with disabilities who may be clients, there are a lot of challenges. Sometimes those challenges could be awareness of what the law can provide you, which forum to approach, the financial aspects, the competent legal representation, to find competent lawyers who can represent your case, to ask for reasonable accommodations and accessibility, to make sure that the judges who are judging your case understand not just the law but also the fine lived realities of persons with disabilities and the practical challenges that poses. So sometimes you have to really read between what the law and policy provides versus what the lived reality is to be able to deliver justice. So my first question would be actually to Rahul. Rahul, you have really spot on the cause of persons with, you have really delivered spot on when it comes to causes of persons with disabilities. You have led many litigations where you have really gotten extremely good outcomes, not for the individual case concerned, but even for the strategy, for policy building, and for building the entire ecosystem of justice and the idea of justice for persons with disabilities. My first question to you would be, what, in your opinion, should be done to build institutional capacity or to bring institutional reforms so that clients with disabilities are able to avail accessible justice in its true and inclusive manner?
Yes. Thank you very much, Amar, for that very kind introduction. And it's an honor to share this stage with Justices Sikri, Manmohan, and Mr. Ambasta. Justice Lokur is also here in the audience. So thank you very much for being here, and I commend QAble and the Sunanda Bhandare Foundation for taking an important step in bringing this issue to the mainstream, and kind of repositioning it from the margins, as it were. So to answer your question kind of squarely, at Mission Accessibility, as you are aware, we've really taken up the cause of providing legal aid to persons with disabilities at scale. So just to kind of provide a few figures, right? As of now, we have about 44 cases which are ongoing in different courts and tribunals across India on behalf of persons with disabilities, many of which are on a pro bono basis. And we take up 3 pro bono cases every month on behalf of persons with disabilities, because as you are aware, there is a strong linkage between disability and poverty, and therefore it becomes important to figure out how to provide competent legal aid at scale to such persons, but in a manner which is also sustainable for us as an organization. And a few things that we've kind of been able to do till now, because one thing I should just say as a prefatory remark is that often you will see lawyers who are doing disability rights cases on the side. They might do 1 or 2 cases, but their main practice area is something different. For us, that is not how it is as of now. As things stand, disability rights is our main practice area, which is why this issue of institutional support becomes important. So what I was saying is that until now, the way we've managed to make this sustainable is through some support from senior lawyers, retired judges, and so on. But going forward, this is something which requires institutional attention, and there are 3 kind of specific suggestions that I have to give in terms of how do we make this litigation and this kind of legal aid possible from a funding and institutional support perspective? First, I think the legal aid authorities have an important role to play here, because as you are aware, persons with disabilities are a class of beneficiaries recognized under the Legal Services Authorities Act. So one good measure which the Delhi High Court has taken in this direction is to empanel lawyers with disabilities on the Delhi High Court Legal Services Committee, so that when cases of such persons reach the committee and there are lawyers with disabilities, so they can, not to say that it should only be given to such lawyers, but they can definitely be considered given their lived experience and expertise in the area. And that also takes care of the funding gap, in the sense that the legal services committee is able to step in, but the litigant obviously can't afford, and the lawyer also needs a form of sustenance. So that is one measure which I think even at the level of the Supreme Court may be considered, and that could be an important step. The second is, from a CSR and CSR and foundations run away from supporting this kind of work, because advocacy is somehow seen not through a very positive lens. Although I personally believe that it is very required to translate the letter of the law into practical outcomes for people with disabilities, but that culture change has to come in terms of making CSR donors and foundations recognize that this kind of work is also worth supporting. And the third is providing more conventional opportunities to lawyers with disabilities, because people tend to then box you in as a lawyer who's only good for disability rights, or who can only do this kind of work. So getting opportunities, conventional legal opportunities alongside your disability rights work is also important from a sustainability perspective.
Thank you, Rahul, for those insightful remarks to begin with. I'll come back to you with a couple of more questions in due course. I'll now move on to Praveen Prakash Ambasta, sir, who has been manning the post of Deputy CCPD at the Chief Commissioner's Persons with Disabilities at the office. Sir, in your experience, what kind of cases do you see mostly coming in? And what level of support from the law, from the path-breaking judgments that Supreme Courts or High Courts keep delivering from time to time on disability rights matter, do you draw upon? And what do you see which can support stronger implementation of orders passed by your Honorable Commission or the State Commissioners? I know it's too many questions in one question, but I want to make the most of the time that we have at hand.
Thank you, Advocate Amar. Thank you, and thanks to the organizers for inviting me over here, giving an opportunity to the CCPD office to voice its opinion through me. And I mean, one is overwhelmed sitting beside the honorable judges here. I know that that's not my place to be here, but with due respect, sir, I would answer. There are three queries that you made, Amar. One is what kind of cases do we receive? So only yesterday we were preparing for a parliament question and studied the last 4 years data, and out of total cases that we receive, almost 25% of the cases are one on, and only ground is that transfer requests from one city to another city. These are employees of various central government departments and public sector undertakings, insurance companies, banks. They want either their transfer order to be revoked or transferred to a place of their choice, which is definitely covered in the Act in Section 20 and 21. But it is, I mean, the numbers are quite huge, and other matters, service matters, are more than that actually. Around, if you club transfer and service matter, they go beyond 55 to 60%. Which means what? Which means that people who are educated, people who can actually afford, they are coming to the CCPD office. But issues related to accessibility, I was absolutely amazed to see that in 2022 we got just 7 complaints on accessibility. 2023 it got increased to almost 79, but 70 of them were filed by either Amar Jain or Rahul Bajaj. So yeah, so one odd case filed by some other person where you were the lawyer grows, So 71 out of 79 cases, courtesy you in the CCPD office. But accessibility has now taken up. 23, 24, we are getting more cases on accessibility and particularly on digital accessibility. And that answers to your second question, what kind of support are we getting? Absolutely, there is no denying the fact that when the CCPD sits in, the hearing, and he draws strength from the one Rajiv Raturi judgment, then Pragya Prasoon and Amar Jain judgment, then very recently another judgment has come in May, Raj Sekharan versus Union of India on barrier-free pavements, right to clear footpath. So when these judgments come, they do help us because we do not have any power of our own other than the mandate in the Act and the judgments which have come from the Supreme Court and High Court. So definitely these judgments do come in to help us in issuing a reasoned order. And when the orders are reasoned, it translates into good compliance. There is one PIL right now before the Honorable Supreme Court, Dr. Satyendra Singh versus Union of India. Without going much in the detail, but that PIL is trying to convey that CCPD and SCPT as toothless tigers and they have no powers and therefore there is no compliance. But let me tell you here that in almost 30 to 40% cases every year, we get compliance even before hearing. So just by issue of a reasoned notice, even in our notice, we try to put forth all the arguments in whatever legal framework, and so therefore we are getting compliance even just by issuing the notice. And in remaining also, yes, definitely there is a cause of concern when the government departments do not get back whether they are accepting the recommendations or they have a reason to reject the recommendation. That is a cause of concern. We are working towards it. But with the help that we are getting from the judiciary, I am very, very hopeful that we will be much more effective. And about the kind of support you were saying, no, I'm absolutely not looking for powers beyond executive. We are absolutely aware that we are totally part of executive. And so there is no intention of donning the role of any court. So within the mandate that we have, for which if I may specify, it is against establishments for which the central government is the appropriate government. That is the language of the Act. And in accessibility and equal opportunity policy, even private establishments. That is what the jurisdiction we have, in which we will keep working. We would like to have a bigger body which takes into its fold other two organs of the state, but that is for some other day. I mean, right now the Act doesn't provide for that. Thank you very much.
So just a follow-up question before I move on to Justice Manmohan and Justice Sikri. My follow-up question to you would be, sir, don't you think there is a need for having strengthened framework for implementation of recommendations passed? Because right now these are recommendations passed by CCPD, and thanks to the Delhi High Court judgment in Mukesh Kumar versus NTPI matter, where it said that binding recommendations ought to have been complied unless there is a justified reason for non-compliance. And I'll tie in this question with your interface with special courts, because many times we have seen that there are matters in CCPD which are appropriate for adjudication by special court that are set up under Rights of Persons with Disabilities Act because they have an angle of criminality involved. How have you seen when you have either referred a matter to special court for their consideration, whether those matters have been effectively taken up, or would you have any thoughts to strengthen that framework as well?
I think this special court system is still, very far from being properly, active. There are two matters which in the last 3 years we have referred, one in the Andhra and another one in Delhi. And our experience has been, with due respect and humility, I would say, that the concerned judge was not aware that the judge is the special court for persons with disabilities. Once they referred it to the district judge, then district judge wrote it back that it is your matter, and then the matter, actually the whole idea of sending it to the special court is to have a speedy trial. But then it got into some other thing that CCPD should file a complaint. There are issues how, being a part of the executive, we can file a complaint in police or before a court of law against another arm of the judiciary, where both organizations will be represented through government councils. So that is one issue we are trying to and in the Andhra matter, what happened is that this is a police brutality matter. Of course, Andhra police is not within the central government control, so we had to refer it to first to the SCPD. When nothing happened, then because the It was a case where a child with disability who was a wheelchair user with 55% disability, in one night she was beaten so much that the disability increased from 55 to 90%. So one hearts bleed what to do in such cases. So therefore we referred the matter to the Chief Justice of Andhra High Court for being taken up. But the pace has not been, in the last 2 years, it has been actually going to be 2 years in September. We have not seen much development in that case. So that is required to be looked into, and I'm sure authorities will take care of that.
Thank you, sir.
If I may
Yes,
be allowed
please.
for one
Yes.
thing about when we're talking about lawyering, I'm saying this because I don't know whether I'll come back or not.
No, you will, sir.
So this
You
one
will
point I really wanted to discuss. In one of the orders of CCPD also it has come. The 1992 judgment of the Indira Sawhney, para 95, the Honorable Supreme Court said that the reservation for persons with disability is not akin to reservation for SC/ST. That reservation is not under 16.4, it comes under 16.1. And we all know that Article 16.1 doesn't even talk about reservation, it talks about equality of opportunity. And so that means there are two things. One is 16.1 talks about employment or appointment. So, whereas 16.4 only talks about appointment. So the scope is larger. Here it is talking about employment as well as appointment. The second thing is that it is about equality of opportunity, not increasing the representation of a particular community in the services or the offices of the state. So when we are talking about lawyering at margins, maybe this is a time when we should also take up, at some level, that in the empanelment of senior government councils also, and all other opportunities, including notary and everything, because this reservation is part of employment. So all employment opportunities, including in judiciary, should also be thrown open to persons with disabilities. That's my view, and thank you. Thank you.
I think, sir, quite a powerful recommendation. I'll now move to Justice Manmohan. Lordship, the question that often keeps me wondering, and it's straight coming from the experience of having represented cause of persons with disabilities, both as a lawyer and as a person living with a disability. More often than not, we have seen that courts have passed historic judgments, but the problem remains in implementation. And unless the cases are monitored by the court for compliance, and which is the trend which we have seen recently picking up, where courts are also monitoring compliance of implementation of those judgments, especially when it comes to matters like disability rights, judgments are more often, paralyzed by implementation gaps. What would you say to that, and what could be effective strategies to address that?
First of all, I would like to thank the organizers. I think it's a very important issue on which this seminar has been organized. What is the need of the hour is to create sensitization, to create awareness. And I think the more awareness is there about the act, about the rights that are available, the more the society will understand, the more the courts will understand, and it will ensure more compliance. Coming to the question, yes, you are right. This requires continuous monitoring of a judgment that has been given. But there are huge issues with regard to continuous implementation. First of all is the court dockets are absolutely full. And really to say that court will pick up this issue and give it absolute priority is not feasible, because every day the court is grappling with so many issues. All said and done, I agree with you that a continuous mandamus may be the need of the hour. But keeping in view the constraints that we have to ensure that our other organs of the state also rise to the occasion. The legislature will have to be aware of this issue and will have to put in place some mechanism whereby the court orders are given effect to. It cannot be done at the pain of contempt. Everything cannot be done at the pain of contempt. And if we start using the power of contempt repeatedly, it also loses its utility at some point of time. Therefore, people must understand And the executive must understand that this is an act which has been passed by Parliament, keeping in view its international obligation. This law is in alignment with the United Nations Convention, which the Government of India has ratified. Therefore, we have to ensure that the executive machinery understands that this is an obligation on them, and this is not some charity being done. After all, this is a right of the person. I think the basic problem that is arising is because everyone is believing that this is some sort of a charity which is being done. You think of any concept, whether it's gender justice, whether it is persons with disability, the mindset of the executive, as well as to a large extent the people who have been adjudicating these matters in the past, has been that we will deal with it as if one is doing a bit of a charity. See, this whole ecosystem has to change. The implementation will arise of judgments with regard to persons with disability when the mindset changes, when the mindset of the common man as well as the executive realizes that this is top priority, this must be done. This is the right of a person. And what is this act doing? It is only giving a reasonable accommodation at the end of the day. It is only ensuring that people who are suffering with either mental or physical disability are given a chance to compete. So the whole ecosystem needs to change. And once that ecosystem changes and people realize that it is a rights-based approach and not charity which is being done, then things will change. But yes, I agree with you. As a short-term measure, the court will have to monitor and will have to ensure that its judgments are implemented. And the best way is to keep the matter pending and to pass continuous orders, which will be in the form of continuous mandamus.
Thank you so much, sir, for those insightful remarks. This actually ties in with my next question, which goes to Justice Sikri. So, what sort of reforms, as Justice Manmohan rightly remarked, that the difference between charity and rights really need to be travelled when adjudicating upon causes of persons with disabilities. What, in your opinion, could be the legal reforms, be it through judicial academies or otherwise, could be brought in to make sure that even judges, lawyers, court staff, and other stakeholders of the legal system are made aware of rights of persons with disabilities, the concepts like non-discrimination, the concept like reasonable accommodation, which you pointed out very beautifully in Rajiv Ratiri judgment as reasonable differentiation before even this term was coined in our act. So what in your view could be those measures?
Thank you, Amar, and I should also thank Sunda Bandare, this foundation, for giving me this chance to be here today and sharing my views. You see, I think you have put a very pertinent question, and I think that's the very foundation of the rights of disabled. As I see the history and over a period of time when, such causes came before me in the High Court and Supreme Court, and I studied about the rights of disabled persons deeply in that context. As I say this, if you see 40, 50 years ago, when the persons who are suffering from various kinds of disabilities, it was what was the psyche of the people or the society towards them? Pity. That's the word if I use. So they will have sympathy with them. They will pity on them. Oh, such a person is suffering from this kind of disease or this kind of disability, etc. Over a period of time, and maybe they are then, those were the time they will be totally secluded. The person is not in a position to do anything because of, say visual disability, or a person whose legs are amputated, etc. So not in a position to do anything, is not a part of the society, and therefore we have to have pity on him, we will, or her, or we'll take care of them. From there, I think the next stage came, it became a health issue. Yes, we should provide them. They are the persons who are entitled to proper health services depending upon their disability, and we should ensure providing them their health. But ultimately, and that is what we see today, and which should have been, but yeah, it came also in other countries that for 40, 50 years ago, in our country maybe little over 30 years ago, firstly after the passing of the first Disability Act in 1996, that it has become a human rights issue. We have to see it from the angle of these persons, and we have to see, and I was really rather admiring this motto, the right to choose, the right to excel. This is the right which every individual in this country enjoys as a citizen of this country, and that is guaranteed in the Constitution of India. And therefore, the persons who are suffering from disabilities are not to be excluded. So therefore, it's a now a right to be included, inclusiveness, and it is based on, when I say right to choose and right to excel, is based on dignity. Here are two persons sitting with us on this dais only, Amar and Rahul. So they were given their right to choose. With proper education, they could, become good lawyers, and they have excelled as well. So therefore, this, the right-based approach, which Justice Manmohan also mentioned, is most important thing which has to be seen. And therefore, when the courts are passing the orders and different kinds of justice judgments are given, these are not, given out of any sympathy, if I may say, or out of any compassion towards this. But it is given because it is a right which is guaranteed under the Constitution. It is a right which is guaranteed under PWD Act, and therefore the courts are only doing their bit to ensure that the right which is guaranteed, it is implemented also in letter and spirit and in action as well. So in this context, when we see, and I come to your question now, is that how we do it? Justice Manmohan has answered in a different way when you asked him a different question about the monitoring, etc. But then, yes, as I have said earlier as well, and what he has also emphasized, sensitization. The judgments of the courts, if they are given, and even when the these commissioners disability are passing orders, various kinds of orders, maybe in the executive capacity, as Mr. Avasti said, but then the implementation becomes very, very important. But judgment should not remain on papers. Then what's the use? That it's not that in a classroom in LLB or LLM we are teaching, and this is what a beautiful judgment, exposition of human rights, etc., in respect of disabled persons. That is not the only way. That may be sensitization of the students, but then the implementation of the judgments, and it has to be ensured that the rights which are given when we are talking about accessibility, and which I started in Rajiv Rituri. I was lucky to have this immediately after the act, when this case came before me, and Justice Sunda Bhandare Foundation also was there, and then it is still monitored. And I'll come to monitoring, that is one aspect. But then more important thing is that the persons who are implementing, and even the every person in the society is sensitized, and it is not a matter of pity, it's a matter of their rights. And therefore we have to see all these individuals from this category also with dignity, and we have to ensure, and it should start from household itself, where the persons are the family members, that the persons who are in the family should ensure that they are given their proper, whether it comes to accessibility or proper education, and the state's role when it comes to employment, etc. And yes, I have said earlier also, for the sensitization as far as judges is concerned, now Mr. Avasti gave that example, when the case goes to a special judge, he doesn't even know that I am designated as judge, or he is not sensitized about this thing, that it has to be fast tracked and it has to be decided immediately. It is not like any other court. So therefore, first thing which is required at that stage, insofar as judges are concerned, proper sensitization and education of theirs, particularly at subordinate level in the judicial academies, which is very, very important. And as I've already otherwise indicated that uh, as law students in the school, yes, there can be special programs about that. But I would say that even in the schools, I mean primary schools or middle level or high secondary schools, we used to have when I remember Justice Madan Lokar would remember, maybe Justice Manmohan also, the paper in civics, so civic sense, etc., all the civility which was taught, which is no more there. So it should be there. Another thing which Rahul also indicated, and I had, I think, discussed with him when he had come on one of the occasions earlier on CSR. Yeah, which is very, very important. Actually, now all the companies, public limited companies, they have their statutory obligation to spend, I think, 3% or some of their gross income towards corporate social responsibility. So it is spent on various other kinds of social activities, but why not for and it can be Rahul, I would say that yes, when it comes to giving the lawyers or the maybe your lawyers collect this initiative, this where they may have some reservation, but why not have some foundation where which is working for the cause, like Surinder Bhandare Foundation, and why not it should be given to them, and from there the funds can be utilized even for spending on the litigation as well. Then nobody would say about that. So that is, so sensitization is most important. And only one thing I would say here, to some extent differing with what Justice Manmohan has said about after the directions are given. Yes, he has said that it should be naturally there should be I mean follow up on that by the courts. Court should monitor. But he, I mean, where I differ is that when he said that look, courts have many other things, and therefore the executive or others who have to implement the judgment, they should be sensitized, which is important. But I think unless in this country the courts coax and the courts threaten the executives, and many times with the contempt also, things don't move. Let us be very frank about it. I remember one case, I was sitting in the High Court with Justice Sinha when he was Chief Justice in Delhi High Court, and under the old Act 1996, there was that the persons with disability get many benefits when depending upon the percentage of disability, etc. So that certificate is to be given, even the employment or education and many other things. So this PIL was filed saying that there are no designated hospitals, etc., which are not under that act. I remember the provision is that the government had to designate those who can issue such certificates. There are none. So how we get the certificates? So in that PIL, it was on the one hand Ministry of Social Welfare, on the other hand Ministry of Health, and both were parties, and the petitioner had made, and both were throwing burden on the other. Ministry of Health said that look, it is for the Social Welfare Department to do it. Social Welfare Department was saying it was, and it was going on for last I don't know how many months. So then what we decided, we said that within 1 week either issue it, or the secretaries of both the these ministries should be present in the court on the next day. And on fifth day, the this notification came. So this is many times you have to take these measures. And yes, courts are busy, courts are overburdened, no doubt about it. But then I think in our preamble, when we talk and we say that the preamble is the soul, first thing is justice. And when we talk of justice, I think, and the courts are given the primary responsibility to do this justice, and particularly social justice, we have to take time, even as judges, for these things. Yes, I mean, whether we sit beyond 4 o'clock and do this case for half an hour or 15 minutes, but we must do it. Thank you.
Thank you for that powerful thoughts, sir. I'll go back to Rahul with a question. Rahul, many times clients with disabilities have faced a problem in many courts that their cases are not heard for months or years, etc. And one measure that has seen significant improvement in is that is Delhi High Court has prioritized cases of persons with disabilities, in a sense that it is listed on top of the board when in the supplementary list, when fresh filed, and later on in the advanced list as the item number 1. Also, not just because it's a case of a person with disability, but also realizing the fact that some disabilities may need that kind of accommodation. So for example, people with invisible disabilities sometimes need access to dark rooms, access to silent places, and sometimes for them to continue to be in the courtroom and monitor the litigation, pace of litigation becomes difficult. So to accord greater opportunity of their cases being heard timely, this measure has been implemented. What could be some specific actionables that could be done across the courts to make sure that persons with disabilities have access to speedy justice?
Yes. See, this I think in my limited experience is the one key demand, that I see, or the one key request, I should say, that people with disabilities often voice in courts and tribunals across the country, which is, providing speedy justice, and figuring out ways of ensuring that, their cases are promptly heard. Now, obviously, this is a demand that every litigant has, no doubt about it. And there can be two views on this. One view being that, look, everybody has to stand in the queue, and you will get your chance when you get it. The other being that we need to take some special measures or affirmative action for this class of people, to provide them access to justice, which also section 12 of the RPWDA talks about. I think the measure which the Delhi High Court has taken has really been a very positive step in terms of ensuring that these cases get the time and attention that they deserve. And I must share with you that there was actually a circular which was issued in 2016 on this to this effect in the Delhi High Court by the then Chief Justice. But when we became part of the accessibility committee, which Justice Shagdar was chairing at the time, we realized that that circular was not getting implemented at that point in time. So then a framework was evolved to have this be a separate category and put it on a priority basis in the cause list. So that kind of affirmative and targeted action can really go a long way in providing speedy justice, whether it be in the Supreme Court or any other courts or tribunals. There are not going to be too many cases of these people. It's not like the regular work of the court will get significantly stalled, in my limited assessment, because this is not one of the areas where, like unlike bail matters, where you will see a large volume of cases, but it is extremely significant. So I think that is very, very crucial. As an institutional reform, I would suggest that. In the meantime, I think it is for the lawyers concerned to really, until that happens, to impress upon the concerned judge that, look, this admission deadline is about to pass. This is the case of a person with a disability. Please take it up on a priority basis so that the purpose and object doesn't stand frustrated. And that then depends upon the workload of that judge and what their perspective is on the issue. So these are only the only two things that I can think of on this, really.
Thank you, Rahul. Coming back to Praveen, sir.
One point, if I may
Yes,
just add, I'm so
please.
sorry. One aspect which I think which is also important here is the disability commissions also, I think, have a very important role to play, because we are the need to go to a court of law like the High Court, Supreme Court, CAT, etc. for persons with disabilities arises if the issue is not satisfactorily resolved at the level of the disability commission. Now we are in an age where we are having specialized forums for everything, from National Green Tribunal to Competition Commission of India, and the disability commissions are also a step in that direction. I personally think there is a grave need to strengthen the powers of the disability commissioners, and here I would disagree with Praveen sir respectfully. I think as of now the statute only gives them the power to make recommendations, and obstructionist and recalcitrant institution, of course some will comply and it's good if they are, but we can't just be dependent on their goodwill. So there are obstructionist and recalcitrant institutions that choose not to comply, and for that we need to vest the commissions with the powers of contempt with the powers of imposing penalties. Of course, with that, you may need to have requirement that the persons manning them may be judicial officers with so and so much experience. Those institutional changes would need to be made. But thinking of the disability commissions as an arm of the judiciary and not a part of the executive is, I think, also an important step on this in this regard. Thank you.
Thank you, Rahul, for that. Praveen sir, coming to you, and the office of CCPD has really played pivotal role because many times complainants come to you without having adequate knowledge of law. Sometimes complainants are anxious, they need psychological support, they need counseling. Sometimes people fear actions. If they take any, if they institute the complaint, there may be some retaliatory measure taken being against them by the institution concerned. What in your opinion, other than the having the legal forum like office of CCPD, etc., could be some of those measures which could improve clients with disabilities perspective and mindset, and provide them a supportive environment to bring disability rights issues to the relevant forum? What could some of those measures be?
Thank you, Amarji. Your question seemed very, very simple until you used the word client with disabilities, because then again we are going back to the judiciary, maybe. But yeah, and first of all, can I answer Rahul?
Sure, sir.
Yeah, what I meant to say is that in the current context, with the current mandate that we have, that is what we can do. But yes, of course, CAT is also a purely executive body, of course, with judicial member, with the admin member. But
That is wrong impression of yours. That is not an executive body.
sir, it is formed by the executive, sir, paid by the executive.
No, that's a
And
different thing.
yeah,
That's
yeah,
the administration.
yeah. But
It's a quasi judicial body.
sir, that's
It's a tribunal,
yeah,
judicial tribunal.
yeah, sir. That's what, because it is paid by the voted expenditure,
That's the
not by
difference.
charge expenditures. So what I'm just trying to bring out the similarities, sir. Similarities. It is also created by executive for the executive. Of course, the judiciary employees from judiciary.
Created by executive, it is created by constitution.
That's so.
By amendment in the constitution.
Yes, sir. That's what I was coming to.
Statute passed.
I was coming to, because it is a constitutional body with the powers of review and contempt. It has got more efficacy. Something of that sort can be thought about for CCPD. That's what I was trying to say, to bring them at par with CAT. The constitution actually doesn't speak about disability at all. So unfortunately, but about the CCPD interventions, I would say to within the given mandate, how we can use the efficacies. One is, as I said, almost 60% of the cases are from service matters, and in the Act itself, Section 23 provides for a grievance redressal officer, and that has not been implemented much in the government departments. So that is also what we are trying to monitor. In every notice on service matter, we are making mention of Section 21, Equal Opportunity Policy, and Section 23, the grievance redressal officer, and we are trying to get the view of the GRO. So at least in that process, the GRO will be appointed in the organization, where right now there is no GRO. Once the GRO has applied its mind and disposed the matter as per the Act, they have got 14 days time. Then thereafter the matter can come to the CCPD office. So that is one way of strengthening the departments itself for the benefit of persons with disability. Similarly, same kind of thing can still happen with judiciary and legislature, even without any proper provision in the Act. So therefore, matters, of course, on accessibility, judiciary, almost 11 or 12 high courts have accessibility committees. But other than accessibility issues, if somebody wants to come without having to go to the formal judicial courts, then that opportunity can also be thought about. That will also give some impetus in the disability right movement. And
Would you want to touch upon, sir?
Training, yeah, I think only the UP Academy has got RPWD in the syllabus. So, sir, Justice Sikri was talking about sensitization. Training will be required for not only for judicial officers, everywhere. Right now, we are having a suo moto matter against 27 training establishments, including from Labasna to all the major Group A and Group B training establishment where we are asking, number one is having an accessible campus, number two, accessible study materials, number three, their website should be accessible. And in the last hearing on 11th of July, the CCPD also started a new process of having a kind of a purple training programs where every training establishment within this year 2025 will have 1 week of training program on disability matters. So we are already collaborating on that. So these things will definitely help us going further. Thank you very much.
Thank you, sir. I'll come back to Justice Manmohan. So, with your closing remarks, I'd like to hear from you. When any matter of disability rights come to courts, and especially at the Supreme Court level, what becomes more important? Is it really the process setting, or is it really the precedent setting?
See, it's like asking a fan of cricket or a cricket lover, would you like to play a T20 or a 5-day match? See, both are crucial. And in fact, if you ask me, at times when a person approaches you, he's in dire straits. He requires immediate relief. It may be that he's been denied access. It may be that he's being discriminated against, which is real and substantial. It requires a quick redressal. So the issue is that would you concentrate on the interim aspect of the matter, or would you like to lay down jurisprudentially a correct law? According to me, it is not just confined to the interim order. Because if you're approaching the matter only from the perspective of dealing with the immediate problem on hand, and that is granting interim relief to the person, then it is indulging in a sort of ad hoc, in a very ad hoc way, and you will not be laying the true foundation for that relief. It must be the relief must be grounded on good, sound legal reasoning, and that you will find only when there is a detailed jurisprudential judgment on that aspect. And only when you have good jurisprudential concept laid down in a judgment would it be followed as a precedent, and would it be applied uniformly, rather than just giving relief to one person by way of an interim order. So I would think that one will have to grant interim relief, but found it on good legal principles so that it becomes a legal precedent, and it becomes a precedent which can be followed by everyone. It must be rooted in law so that everyone knows that no one is giving charity. It is based on a right. It is based on the interpretation of the act, which is giving reasonable accommodation. In a nutshell, I would say it has to be, the judgment of the court has to be based both in empathy as well as vision. If you don't have both, it will be lacking. And you must grant interim relief because that's the need of the hour, but it must have a sound rationale to support it. Otherwise, it'll just be a one-off remark giving relief to one person rather than the entire community.
Absolutely.
And God forbid, if the court goes down the wrong line, it can happen. It'll get corrected because you have given some rationale behind it. That rationale, if it is not appealing to the public or to the legislature, they'll correct it. They'll pass an amendment.
Right.
So it's very important to lay down the law properly. When Justice Sikri said that, I was saying that it should not be continuously implemented. I was only saying that let's be realistic about the situation.
Right.
If you think the court is going to monitor a matter on a daily basis, it may be raising the hopes too high, which will not be implemented. Because see, to expect that a judgment would be implemented on a daily basis is very difficult.
Right.
And we have to be realistic, and we have to ensure that all organs of the state work towards it. Today, everything can't be left at the judiciary's doorstep. If you think that only judiciary is going to resolve the problems of this country, you're sadly mistaken.
Right.
We may just compound it at the end of the day. See, unless until all organs, including the society, works for it, we'll have a tremendous issue at hand. And let me just give you a simple instance in Delhi High Court, what we did on the administrative side. It is not just on the judicial side where the courts can work, just look at the administrative side. We have just opened a small cafeteria which is run by the mentally challenged children. It's a absolute homegrown initiative of the Delhi High Court, run by Shaurya Foundation, of which its convener is one of our senior lawyers, Ravi Gupta. His child also suffers from that disability. And we have opened, just given them a small area to run a cafeteria. The children are running it primarily. They have tied up with Sagar restaurant. Look at the number of people, the lawyers who go there. Look at the people, look at the way the people are sensitized about that issue. When you go to that cafeteria and then you come back to court and you understand when a rights issue is being argued over there, your whole approach will change.
Right.
When the judges go to that cafeteria or they call for something from that cafeteria, they understand who's running that place. Just see, you need empathy in this society, which is lacking. We have complete lack of understanding of the issue that we are dealing with. That is persons with disability. Unless until you have an understanding, you will not be able to approach the issue. And that, I think, is very, very crucial, rather than just laying some abstract principle of law, you know, just for consumption in the newspapers or in the textbooks. So the real issue is to sensitize the society, to ensure all organs of the society work together, and one should not expect that it will be solved only by the judiciary. If you think it will be solved only by the judiciary, I don't think that's very accurate. We may take the lead in the matter because we are people who have gone through a legal training, who are educated, who understand the rights of the persons suffering from disability. We can surely take the lead, but it will only get implemented at the ground level when you and I work together. And that, I think, is the core issue. These sort of seminars serve a huge purpose when they are sensitizing each one of us in this room of what is the issue that we are grappling with, what is the dimension of this problem. See, the whole approach needs to be changed. See, we cannot approach it from a feudal mindset that today I have the power, I will do something for you. It's not that. We are not doing any charity. I am repeatedly saying we are dealing with person who has a right in law. That right needs to be given to him. He must be aware of his right. He must come in case there is a grievance. He must be able to raise it with the executive, with his member of parliament, with his MLA. They must be able to deal with it on a timely basis. The person to whom he goes and raises his complaint must be aware of his duty, must be aware of the disabled person's rights. And I think that is very important. Therefore, I think what needs to be done is that we need good legal foundation, which should be done by way of judgments, but people need to be sensitized and it needs to be implemented at the ground level.
With that very strong foundation, and before I go to Justice Sikri for his conclusive remarks, what we have really uncovered today is the need for bringing legal reforms, need for bringing sensitization, need for executive, judiciary, and legislature to work in tandem to make sure that the historic judgments that are laid down by the courts are realized in its true potential for the society at large. And I now come to Justice Sikri. Sir, you have laid down futuristic vision always in your judgments, be it Jija Ghosh, be it Rajiv Raturi, and many more. In your opinion, what is the future of disability rights? In my humble opinion, now the time has come where we should move from rights approach to value-based approach, where person with disabilities value is realized in the society as contributor to the economy, as contributor to the society, and as a citizen. What in your opinion could be the future of disability rights, and how people with disabilities should be viewed in near future to come?
I think you have hit the nail. That is what I wanted to say at the end when I said that how we have progressed and we are at right base from pity to health issue to this and now value based. And again, I go to this motto of Sunanda Bandare Foundation because ultimately it is the whatever are the potentials of a person, whatever is the worth of a person. And I say that when we talk of inclusivity also in the society, that means each and every person, irrespective of their disabilities or I would say abilities, etc., they are important part of the society, and everybody has right to contribute towards the progress of the nation. And it would be a misgiving and a very shallow thinking or narrow thinking to say that only the persons who are so-called able, if I'll use that expression, only they can do this work and not the other persons. So that is a very myopic view of what the other persons can achieve. We know now that how in Paralympics our people have done wonderful, in the last Olympics, how many prizes they have won. In various other fields, it's not time to recount all that, how they are doing. So therefore, it is, we have to now recognize the value and value based, and that approach, I think now, yes, Justice Manmohan is there. He's still a sitting judge. Whenever he gets a chance, now we have laid down the foundation of rights based. So let it now come to value based also, the next step, which would be very, very important for inclusivity and for recognition of, or giving due recognition to the persons with disability. I think that's the next step, and it, I won't here include only the persons with disability, but the last session also, which is coming there, the value based there as well. Thank you very much.
Thank you so much. I think, honestly speaking, if you want to read about Rights of Persons with Disabilities Act, the couple of concepts before I open up for questions and answers, you'll read up on non-discrimination, that no person with disability should be discriminated solely on the ground of disability. The concept of accessibility, which is to ensure that every person with any ability is able to access products, services, and environment. The concept of reasonable accommodation, which is basically a specific individualized measure that is taken when accessibility fails to accommodate their needs. All of these concepts are actually, if you see, have been put into the act because ultimately the idea is that a person with disability should be able to realize their full potential, not because it's a right for them, not because it's an obligation, but because it is a means to make sure their value is realized in the society as a contributor. With that, I open the floor for any questions and answer.
I think because that's what I was
Next
telling
session
him.
also
Next
have to.
section.
So can we do one thing? We can do the question. If anyone has anything specific, we can ask when we have our tea.
Sure. So, apologies for not being able to timely finish the sessions. Questions were important and opinions were important, but look forward to see you in the break with any questions that you may have. Thank you.
I just very quickly, I want to just thank. I had a lot written here, but since we are running out of time, I want to thank Justice Manmohan, Justice Sikri, Mr. Ambasta, um, Rahul and Amar, of course, and Archer from QAble for coming here today and so passionately discussing and talking about these issues. We really hope that in some small way today's conference will make a difference. I want to just tell you, when we were talking about how sometimes the executive and all does not, but and I can tell you in our own litigation, the Justice Sunanda Bhandare Foundation PIL, it was filed in 1998 when the old act was there. Till 90, even then, even though we had a judgment which said all states would comply with the old act, none of them were compliant. Then in 2016, a better new act came. 2017, we got a judgment saying that now you will all comply with the 2017 Act. And till date, the Supreme Court has been monitoring it. Despite the fact, I mean, now by now, but can you imagine? I think the last hearing was about 4 or 5 months ago. Still, some of the states and union territories were not compliant fully. That is the state of affairs, sadly, in our country. I do hope that, discussions like this will make people and the society at large and the executive and judiciary more sensitive to these issues. And I also, one of the most important, I think, things which have come out in today's conference is bringing relief in court, not from pity to dignity, and that is the need of the hour. With this, I thank all our panelists and all of you for coming here today. And of course, all of you will continue to be with us, but I'll request you all to please join us for a cup of tea and coffee. Thank you.
Thank you so much for having us here. Thank you.